Good evening, everyone. If I am audible, please comment. If you can hear me, please comment in the comment section. Okay. So, today we will discuss the three organs of the state. Now, here state means the 28 states that are there in the Indian Union, for example, Punjab, Haryana, Himachal Pradesh. So, today we will be discussing the three organs of legislature, executive and judiciary at the state level. We have already discussed the legislature and executive at the union level. Today we will discuss the legislature and executive at the state level, and then we will discuss the judiciary both at the union and at the state level. So, this is how we are going to proceed. So, when we talk about the state executive, the first office that comes at the top is that of the governor. So, we will talk about the governor first. Yes. You can ask any questions that you have in the comment section. So, as we know, part 6 deals with state. Part 6 deals with state. So, in part 6 there is a provision for governor from articles 153 to 167. From articles 153 to 167 there is provision for a governor for every state. And just like, so when we are doing governor, what you have to understand is that the governor is the exact parallel of the President of India. So, whatever the president is at the union level, the governor is at the state level. Yes, some provisions of the constitution can be amended only after ratification by the state legislatures of majority of states. Definitely we did this under article 368 of the constitution, under article 368 of the constitution, which deals with the procedure for amendment. There are two types of amendments. One is by the special majority of parliament alone, and second is by the special majority of parliament and by the consent of at least half of the state legislatures. So, this type of amendment is known as the statement that you are making, that some provisions of the constitution can be amended only after ratification by majority of the state legislatures. So, this is what it means. An example of this kind of amendment would be 101st constitutional amendment that deals with the goods and services tax. That amendment was done after it was ratified by at least half the state legislative assemblies. So, going back to what we were doing, so the governor is the head of the state executive. Governor is the head of the state executive, and all his powers, executive, legislative and financial, are parallel to that of the President of India. So, all these powers the governor enjoys this in the same way as is enjoyed by the President of India. So, he is the head of the chief executive. And how is he appointed? He is appointed by the central government. He is appointed by the central government, but it would be wrong to say that he is a pawn of the center. It is a different constitutional office and it has its own standing, it has its own autonomy. Just because it is appointed by the center does not mean that he does not get to exercise his own discretion. Formally, he is appointed by the President of India. the governor is appointed by the President of India. As far as the conditions of his office are concerned, there are certain conditions which have been placed. For example, number 1, to become a governor, a person should not be an MP or an MLA. That means a person should not be a member of either House of Parliament or either House of State Legislature. That includes member of Legislative Council as well. So, he should not be a member of any house. Further, he should not hold any office of profit. He should not hold any office of profit. And office of profit does not include ministerial office, the office of the president, the office of the vice president, the office of ministers. They are not included in office of profit. Right? Another provision is that one person can be appointed the governor of one or more states as well. One or more states as well. This provision was not there earlier. This provision was added by the 7th Amendment to the Constitution. By the 7th Amendment to the Constitution. Earlier, the provision was that only one person can be a governor of one state. Now, one person can be a governor of one or more than one states. In this particular case, the salaries and emoluments of that governor are shared by those states. For example, there is a state of Punjab and Haryana. So, if there is a common governor for both these states, both Punjab and Haryana governments will share the salaries and emoluments to be paid to such a governor. Then the governor enjoys immunity. The governor enjoys immunity as far as criminal cases are concerned. So, no criminal cases can be instituted against a governor while he or she is in office. However, civil proceedings can be instituted against a governor by giving a 2 months notice. By giving a 2 months notice. So, just like the provision that is there for the President of India, all the provisions are parallel as far as the governor is concerned. Then the appointment of governor is by the president, but the oath of office to the governor is administered. Now, the President of India, who administers oath to the President of India? The Chief Justice of India. So, the parallel of Chief Justice of India would be the Chief Justice of the State High Court. So, the Chief Justice of the concerned State High Court administers oath to the governor of the particular state. Right? Articles are not very important to be mentioned. I told you in the beginning that the articles are from Article 153 to Article 167. You don't need to remember all the articles. If you want to remember the articles, you should remember the articles from Article 12 to Article 51. Those articles are very important. From fundamental rights, from directive principles, and from fundamental duties. Those are the articles that you should remember. A person can be a governor of as many states as there are. There is no such upper limit. A person can be a governor of 3 states or even 4 states. There is no such limit on that. Right? Then, if we talk about the term of office of the governor, the term of office of the governor. Now, this is the most controversial part. There is no term mentioned in the Constitution of India for which a person can be governor. What is mentioned is that he should serve as governor till the pleasure of the president. Now, this term pleasure of the president simply means that the governor can be appointed at any time and he can be removed at any time as and when the president decides. So, there is no such fixed term mentioned for the governor of a state. However, various committees like the Sarkaria Commission on center-state relations and similarly the Punchi Commission on center-state relation, they have recommended that the governor shall be given a 5 years fixed tenure. However, this provision is not mentioned in the constitution. You should be very careful. No term for governor is mentioned in the constitution. Only it is written that the governor shall serve till the pleasure of the president. So, 5 years is not mentioned anywhere in the constitution of India. Right? Then let us discuss some powers of the governor in brief. Now, powers of the governor. So, we did the powers of President of India. Similarly, the powers of governor, number 1 are the executive powers. So, the executive powers extends to the appointments at the state level. Now, this provision is exactly parallel to that of the President of India. So, all the appointments at the state level, whether they are of the election commissioners, whether they are of the judges of the High Court, or whether they are of the other important constitutional functionaries, it could be finance commission of that state. So, every state also appoints a finance commission. So, all these appointments are made by the governor. Now, one important thing you need to remember is that just like president, the governor is only a figurative head, the governor is only a nominal head, and the real head here is the chief minister of that state. So, the parallel of prime minister in union level is the chief minister at the state level. So, the governor is the nominal head, nominal executive head at the state level, and the chief minister is the real executive head. So, here all the appointments are actually made by the chief minister, but symbolically they are under the seal and signature of the governor of that particular state. Similarly, he has the right to address the state legislative assembly, on 2 particular occasions. The first occasion is after every election to that particular assembly, and the second is in every new year. So, 2 times the governor addresses the session of the legislative assembly, or in case the state has 2 houses, the joint sitting of both the houses is after every election to the legislative assembly and once or the first session of every new year, which is usually the budget session. So, the provision is also again exactly parallel to that of the President of India. If we talk about the legislative powers of the governor, now legislative powers again mirror the legislative powers of the President of India. So, the legislative power includes the power to sign the bills that have been passed by the state legislature. Similarly, the power to certify a bill as a money bill, or we can say that any money bill which is to be introduced in the house has to need the prior recommendation of the governor. This again is a legislative power of the governor. Then the governor can nominate. Now, this is an important point. Now, this is a deviation from what the president does. So, we know that the president nominates 2 members from the Anglo-Indian community to the Lok Sabha and 12 members from the field of art, science, literature and social service to the Rajya Sabha. But here there is a difference, that the governor nominates 1 member from the Anglo-Indian community to the Legislative Assembly, 1 member from the Anglo-Indian community to the Legislative Assembly. So, here is a difference. Now, here in the lower house, a person, only 1 seat is reserved for the Anglo-Indian. However, in Lok Sabha 2 seats are reserved. Similarly, the governor can nominate 1/6 of the total members to the Legislative Council. Now, those states which have an upper house, we will discuss the composition of the upper house as well, that how upper houses are actually made up. So, out of those total members, 1/6 of the total members are nominated to the Legislative Council by the governor. Now, these are again from the same fields, that is art, science, literature and social service. So, these members are from the same fields of art, science, literature and social service. However, very importantly, one more field is mentioned here from which a person can be nominated to the Legislative Council, and the field is cooperative movement. So, cooperative movement is another field. So, a person who has done a significant work or significant groundwork or achievement in the cooperative movement of the state, that person can be nominated to the Legislative Council of that state by the governor. Right. Then we have, yes, the article does mention 5 years term of governor, but it mentions that the governor shall serve only till the pleasure of the president. So, this term is not fixed as such. It is not fixed in a manner as is fixed for, say, the President of India, or as is fixed for the Prime Minister of India, or as is fixed for any other constitutional office, for example, the election commissioners, or for the Controller and Auditor General, there is a 6-year term. So, in that way this is not mentioned, it is just the upper limit that is mentioned there. Ultimately, the 5 years term can be overridden by the pleasure of the president, and that is why we have seen that no governor enjoys 5 years of absolute term. Whenever the central government changes, now this is a practical aspect of governor, whenever the central government changes, it changes most of the governors that are serving in the states, because then they appoint all the loyalists or all the party functionaries to that particular office. So, that is a problem that we encounter. That is why the office also has to suffer a lot of criticism as well, right. So, yes, the article does mention that there is 5-year term, but it is subject to the pleasure of the president. That means the pleasure of the president overrides whatever is there written in the constitution. But technically, yes, you are right that the term is mentioned in the constitution, but the term is subject to the pleasure of the president. Then the governor can also promulgate ordinances. Now, ordinance here again means the same meaning as we discussed in the President of India. The ordinance is a temporary law which is in force for 6 months. It is in force for 6 months, and within these 6 months it has to be passed by, if the state has 2 houses, then from both the houses; if the state has 1 house, then from the Legislative Assembly. So, this ordinance can be issued by the governor of the state. Then, if we talk about the financial powers, in financial powers, the first power is the state budget. So, the state budget can be introduced in the house only on the recommendation or only on the prior recommendation of the state governor. Similarly, any other money bill can be introduced in the Legislative Assembly only on the prior recommendation of the governor. This provision is also parallel to that of the President of India, right. Then there is a finance commission for the state as well, as we already discussed. So, there is a finance commission for the state as well, which is to be appointed by the governor of that particular state. This also comes under the financial power of the governor. Then now when we did the President of India, we did that the President enjoys military powers. We also did that the President enjoys the diplomatic powers, and we also did that the President enjoys the emergency powers. However, what you should keep in mind is that these 3 types of powers are not enjoyed by the governors of states. Why not? number one, military power. So, military is a subject of the central government. Military is a defense which comes under the union list. So, it is not a state subject. That is why governor has no power as far as military is concerned. Secondly, diplomatic powers. Now, diplomacy again is a external affairs. So, external affairs is again not a matter under the state's ambit, it is also a union matter. That is why it is not there. Emergency again is the president's prerogative. However, there is an exception in emergency, and that exception is that the governor can recommend to the central government for the imposition of emergency in the state. So, we know that emergency is of three types. There is national emergency under Article 352, then there is state emergency under Article 360, and then there is financial emergency under Article, I am sorry, it is 356, it is 356, and financial emergency is under Article 360. So, these are the three types of emergencies. Now, as far as state emergency is concerned, which is also known as president's rule, if the governor recommends to the president that the state emergency be imposed on the ground that the administrative machinery of the state has broken down and the administration of the state cannot be carried on in accordance with the constitution, then that is a fit ground for the central government or for the president theoretically to impose that emergency in the state. So, this alone, but that cannot be counted as an emergency power. It is just a power to recommend to the president to do something. So, the military, diplomatic and emergency powers are not exercised by the governor, they are exercised only by the President of India. Similarly, the veto powers. Now, in veto we discussed that there is suspensive veto, then there is absolute veto, and then there is pocket veto. So, in case of governor also, the governor enjoys all these types of vetoes. However, in addition to this, there is another type of veto that the president enjoys, which is not exactly a veto. The governor can reserve a bill passed by the state legislature for the consideration of president. So, there can be a bill which is passed by the state legislature, which when goes to the governor and the governor thinks that the bill has such provisions which can undermine the provisions of the union list subject or for any other reason. So, that particular bill is referred to the president by the governor. So, this provision is there, and once the governor recommends such a bill to the President of India, the governor has no power whatsoever on that particular bill. So, this provision is there, and after that, that bill goes for the consideration of the president, and the president again has all the powers which are already discussed. In this case, there is one thing: if such a bill that is reserved for the president goes to the president can exercise any of its veto, and the president can also refuse to sign. The president can refuse to sign over this particular bill. However, the difference is, if the parliament sends a bill to the president and president refuses to sign it and sends it back, if the second time the parliament sends the same bill to the president is bound to sign it. However, in case of a state legislature, if the president sends a bill back to the state legislature and the state legislature again sends the bill to the president is still not bound to sign. That means the power of suspensive veto as far as president is concerned is of a wider amplitude with regard to state bills. If you have any doubt about this point, you can ask me. I can explain you once again. If a bill that has been returned by the president to the Parliament of India is sent again by the Parliament to the president is bound to sign it, because president cannot return the same bill for the second time to the Parliament of India. However, when a bill is sent by the state legislature to the President of India and the President of India returns it and the state again sends the same bill to the President is not bound to sign it. Even n number of times, the President is not bound to sign it. That means, as far as the state legislature is concerned, the suspensive veto of the President has a much wider amplitude. The President can send the bill back to the state legislature even for 10 times, 20 times, and is not bound to sign it. So, the suspensive veto is very wide in case of the bill that is reserved by the governor for his concern, right. I hope you have understood what have I said. So, now let us see some special roles played by the governor in some various states. What are some special powers of the governor in various contexts and in various states also? There are certain states where the governors have been given some extraordinary powers. First of all, the power that I told you about, to send a bill to the President. So, this is one discretionary power of the governor. Now, this power can be exercised by the governor even if the chief minister does not recommend it. Even if there is a change in the bill or even if there is no change in the bill, the President can send that bill back again n number of times and is not bound to sign it. The President may recommend some changes in that state bill and the state may do that change. If the state does that change that the President has asked for, then the President will sign the bill. But if the state does not affect that change and sends the same bill to the President will not sign it, because second time the President is not bound to sign it. That is the more important thing. So, the bill passed by the state legislature is not very powerful, but the bill passed by the parliament is powerful in this context. This is what you need to understand. So, this is first discretion of the President, that of the governor, that a governor can send a bill for the consideration of the President even if the chief minister and state council of ministers does not recommend it. The second important provision is he can recommend imposition of Article 356 in the state even if the chief minister does not recommend it. So, this is the discretion of the governor. He can recommend to the President that Article 356 be imposed in the state because the constitutional machinery in the state has broken down and the usual administrative work cannot be carried on in accordance with the provisions of the constitution. Then another provision is if the governor is also administering a union territory. If the governor is also administering a union territory, in context of that union territory, the ministers do not have any say whatsoever. For example, the governor of Punjab is also the administrator of UT Chandigarh. The governor of Punjab is also the administrator of the union territory of Chandigarh. So, when he is acting as a governor of Punjab, he has to act according to the advice tendered by the chief minister of Punjab and the ministers of Punjab. So, he is bound by it. However, the same person is when acting as the administrator of the union territory of Chandigarh is not bound by such advice. The second point is that the governor can recommend the imposition of Article 356 in the state, and in this regard he is not bound by whatever the chief minister has told him. Article 356 is state emergency. This is a discretionary power of the governor. He can recommend the imposition of state emergency in the state even if the chief minister does not say so. Right? Then under Schedule 6 of the Constitution, there are provisions for 4 particular states: Assam, Tripura, Meghalaya and Mizoram. So, these 4 states are specially mentioned under Schedule 6 of the Constitution, and the tribal areas and the tribal autonomous districts in these states have some special powers which are not given to any other local government body. So, the amount of the budget which is to be given to those tribal autonomous districts in these particular states is to be decided by the governor. Say the state government passes a budget worth rupees 1000 crore. Out of that 1000 crore rupees, the governor can by his discretion allocate some particular sum to the tribal districts or tribal areas of the particular state, and it will not be interfered by the state legislature. So, this is a discretionary power with the state governor, and that particular sum has to be for the royalty that has been accrued to those districts as a result of mineral exploration. This has been done because in these 4 states there is a lot of tribes that are living, and also there is a lot of mineral exploration. However, in the event of the exploration of minerals, these tribals remain poor. So, some royalty has to be paid to those tribals so that they can also get to earn something when there is mining in those areas. So, for that purpose the governor has been made the custodian of that economic benefit. So, say in a tribal area of Assam some mining is taking place. So, the tribals who are living in that mining area should actually get some royalty out of that mining, but to ensure that the governor is there. So, the governor ensures that they get their dues. Right. Similarly, there are some other discretionary powers of the governor, just like we discussed in the case of President of India. Just like we discussed in the case of the President of India. So, what were the discretionary powers of the President of India? Some powers were, for example, in case no party gets a clear majority in the state legislative assembly elections, in that case the appointment of chief minister, in case no party has clear majority, that is the discretion of the governor of the particular state, right. Then when the CM is not able to prove its majority, which is usually held in case of a no confidence motion, which is what is happening these days in the state of Madhya Pradesh. So, if you are thorough with the current affairs, you should know that in the state of Madhya Pradesh, which is in a state of crisis actually, the governor is duty bound to ensure that the government which is serving there enjoys the majority in that particular house. So, the total strength of the Madhya Pradesh assembly is 230 MLAs. So, for making a government 116 votes are required, but in this particular time 6 members have been disqualified, which takes the total number to 224. So, for out of this 112 or 113 is the majority mark, the effective majority mark in the Madhya Pradesh Legislative Assembly. The BJP and the Congress are very close. So, the BJP has 107 members, whereas the Congress has 108, and the majority mark is this. So, this is a precarious situation. Now, the governor has asked the Chief Minister of Madhya Pradesh to prove his majority on the floor of the House, and on that a decision will be taken in a day or two. The governor and the BJP members particularly have approached the Supreme Court of India to conduct a floor test in the Legislative Assembly of Madhya Pradesh. Once the floor test is held and the Chief Minister of Madhya Pradesh is not able to prove his majority, then he will have to resign. So, this is a discretionary power of the governor. Now, the governor of Madhya Pradesh at present is not asking for the advice of the Chief Minister in this particular matter. He has his discretion in which he can recommend to the court or to anyone the imposition of floor test in that particular house. So, this again is a discretionary power. Similarly, the dissolution of house or the dissolution of the Legislative Assembly in case the chief minister has lost his confidence in the house. So, this is what is going to happen if the present chief minister of Madhya Pradesh is not able to prove his majority. The governor will first of all dismiss the government, and secondly, if the opposition, that is the BJP, if the opposition also is not able to prove that it is in majority, only then the house will be dissolved. But before dissolving the house, every chance has to be given to the opposition and to all other parties also, if they can show that they have majority in the house. So, once the chief minister of Madhya Pradesh resigns, after that the governor will give a chance to the opposition, which in this case is the BJP, and if the BJP is able to prove that it has the numbers in the house, only then it will be allowed to continue as the chief minister of the state, otherwise it will not be. So, you should be really thorough with the current affairs, because as far as polity is concerned, the entire polity gets repeated in the current affairs in one form or the other. It was also in news some months back when the crisis in Karnataka was brewing. So, at that time also the same or something similar actually happened. Then there are certain states under Article 371 of the Constitution. So, under Article 371, from Article 370A to Article 371J, there are various provisions. So, Article 371 talks about Maharashtra and Gujarat. Then Article 371A talks about Nagaland, Assam, Mizoram, Andhra Pradesh. This is Manipur. This again talks about Andhra Pradesh. Sikkim, Mizoram, Arunachal Pradesh, Goa, and Hyderabad, Karnataka region. So, Article 371, which is a part of Part 21 of the Constitution. So, Part 21 talks about the temporary, transitional and special provisions. Under this, there were two articles, Article 370 and Article 371. Article 370 was particularly for the state of Jammu and Kashmir, which has now been done away with, and Article 371 talks about all these particular states. So, in all these particular states, there is one or the other exception which is there. One or the other exception is there. In most of the cases, the governors of these states have been granted certain particular powers. For example, under Article 371, for Maharashtra and Gujarat, there are particular provisions. So, under this particular article, there are development boards which have been set up. There are development boards which have been set up, and it is the responsibility of the governors of these states who will administer those development boards. For example, there are two regions of Vidarbha and Marathwada. Vidarbha and Marathwada in the state of Maharashtra, which are known for drought-like situations where there is a lot of agricultural distress, for which the governor has to take certain special measures. Similarly, in Gujarat, there are two areas, Saurashtra and Kutch. In these two areas, again, there are development boards for which the governor of Gujarat has certain special powers. Similarly, for most of the other states, for example, the state of Nagaland, Assam and Manipur, there are special law and order powers. There are special law and order powers with the governor of the state. The reason for that is that these states have been the hotbed of ethnic conflicts in the past. So, there is a lot of ethnic problems in these states of Nagaland, Assam and Manipur, and that is why the governor of that particular state has been given special powers for administration of those areas. Similarly, for the state of Sikkim, for maintenance of peace, some provisions have been given for maintenance of peace. That means the governor has certain discretionary powers as far as the law and order is concerned. The same goes for the state of Arunachal Pradesh also, for peace and for law and order. So, the maintenance of law and order. Most of the states, if you notice, are in the northeast of India. So, all these states that are under Article 371 of the Constitution grant some special powers to the governors of those states for the administration of those areas. Either there are development boards or there is law and order problem in these particular states. So, in the state executive, what comes next is the office of the chief minister of the state. So, the office of the chief minister is there. Now, this office again is exactly parallel to that of the prime minister. The prime minister, what the prime minister is at the union level, the chief minister is at the state level. Now, chief minister can be a member of either house of state legislature, either house of state legislature, can be legislative assembly or it can be legislative council as well. Secondly, he is administered oath by the governor. He is administered oath by the governor. No, the Northeastern Council does not come under the governor. The Northeastern Council comes under the Union Home Minister. We already discussed the governor's discretionary powers, that he can recommend the imposition of president's rule, he can send a bill for the consideration of the president, right. So, the oath is administered by the governor and he can resign also to the governor only, right. Then a chief minister is the real executive head, is the real executive head of the state, and all the administration of the state revolves around him or her. Yes, you have rightly asked this question. Even if a chief minister is not a member of either house of the state legislature, he can still become a chief minister, subject to the condition that he should become a member within 6 months, within 6 months of such election. The same provision which was there for the union ministers and the prime minister, the same provision is there for the chief minister and state council of ministers as well, right. All other functions and powers of the chief minister are analogous to that of the prime minister. So, just like we discussed the powers of the governor of a state, just like we discussed the powers of the governor, whether it is the legislative powers or financial or executive powers, all those powers are actually exercised by the chief minister of the state. This is what you need to remember. Is there any scrutiny of court with regards to the discretionary powers of the governor? It depends on a case by case basis. If the governor has taken a decision, it can be challenged in the court of law. Of course, it can be challenged in the court of law. Right. So, apart from the usual powers of the chief minister, which we have already discussed, for example, he can call the sessions of the assembly, he certifies the business of the government, he takes all the decisions of the government. So, all these are the powers of the chief minister. Apart from that, certain special powers of the chief minister or certain special functions of the chief minister, certain special functions of the chief minister. The first function is that the chief minister is the chairman of the state planning board. The chief minister is the chairman of the state planning board. This is the first function. The second function is that the chief minister is a member of Niti Aayog's governing council. So, all the chief ministers are members there, and the chief minister of every state is also a member by that virtue. Number 3 is that the chief minister is a member of the zonal council. So, there are 5 zonal councils in India: the Northern Council, the Western Council, Southern Council, Eastern Council, and the Central Council. These are the 5 zonal councils in India, which are composed of 5 to 6 states each, and in all these zonal councils the chief ministers are the members. So, for example, if there is a zonal council of Northern Zonal Council, so of that there are 4 to 5 states which are members, states as well as union territories. For example, Haryana, Punjab, Himachal Pradesh, Rajasthan, these all are members of the Northern Zonal Council, and Northern Zonal Council and all the zonal councils for that matter are headed by, yes, can you tell me in the comment section who is the chairman of all the zonal councils? These zonal councils are composed of states in every part of India: Northern Zonal Council, Western Zonal Council, Southern Zonal Council. So, can you tell me, if chief ministers are the members of these councils, who is the ex officio chairman of these zonal councils? Who is the ex officio chairman of these zonal councils? The Union Home Minister, yes, the Union Home Minister, not the Home Minister, because Home Minister is there in every state. So, the Union Home Minister is the chairman of all the zonal councils, and right now the Union Home Minister is Mr. Rajnath Singh. That means Mr. Rajnath Singh is the chairman of all the zonal councils in India, and the deputy chairman of all the zonal councils is the chief minister of one state by rotation. So, this is the rule. Say there are 5 states in a particular zonal council. So, the chief minister of each of these states will be the deputy chairman of that zonal council for 1 year by rotation, and the chairman will be fixed, that is the Union Home Minister. So, the meetings take place every year. Recently, 3 to 4 months back, the Northern Zonal Council meeting took place in Chandigarh itself, where the chief ministers of Punjab, Haryana, Rajasthan, all these participated. So, you should keep an eye on such developments as well. Then we have the State Council of Ministers. Then we have the State Council of Ministers. Yes, it is Mr. Amit Shah. I am sorry. I mistakenly said that it is Mr. Rajnath Singh. Mr. Rajnath Singh is actually the Minister of Defence. So, Mr. Amit Shah is the Union Home Minister. I stand corrected. Mr. Amit Shah is the Union Home Minister. Right. So, he is the head of all the zonal councils in India by virtue of being the Union Home Minister. So, just like we discussed the Union Council of Ministers, similarly there is State Council of Ministers. So, the State Council of Ministers is headed by the Chief Minister of that particular state. The oath to all the ministers is administered by the governor of that particular state, and in case they have to tender their resignations, that is also done to the governor of that particular state. However, in tendering their resignations or in removing them, either in tendering their resignations or in their removal, the governor does not have any discretionary power. The governor has to proceed as per the instruction of the chief minister. So, the governor cannot remove any minister on his own will or out of his own discretion. He has to do so as per the instruction that is tendered by the CM, since chief minister is the head of the council of ministers in every practical sense. Right. Now, there are certain important provisions as far as State Council of Ministers are concerned, which is again the same as we discussed in Union Council of Ministers. First is either house. Now, what it means is that a person who is a member of either legislative assembly or legislative council is eligible to become a minister. He can be from any house of the state legislature. Secondly is the 15% rule. Now, as per the 15% rule, the total number of council of ministers cannot and should not exceed the 15% of the total strength of the legislative assembly. Now, let us take one example. If the legislative assembly of a state, let us take the example of Haryana. So, Haryana has a total of 90 members in its legislative assembly. That means the total number of ministers cannot exceed 15% of 90, which comes out to be roughly 14, which is rounded off on the upper edge. So, 13.5 or 14, that means including the chief minister, the total number of ministers in Haryana cannot be more than 14. Similarly, if we take the example of Punjab, so 117 is the total strength of the Punjab Legislative Assembly. So, if we do the 15% of this, that means around 17. So, not more than 17 or 18 ministers can be there in Punjab, including the chief minister of Punjab. There is one exception to this 15% rule that we will do well, however, when we will do the union territory topic, but let me tell you straight away, there is also a 10% rule. The same rule that the number of ministers including the chief minister should not be more than 10%, and this rule applies only and only to the union territory of Delhi. This 10% rule is applicable to the union territory of Delhi. That means in Delhi the total MLAs are 70. So, the total number of ministers including the chief minister cannot be more than 7. So, the rule of 15% becomes the rule of 10% as far as the union territory of Delhi is concerned. So, the current chief minister Mr. Arvind Kejriwal and all other ministers total cannot exceed 7 in case of Delhi. This provision has been done because they do not need so many ministers. 2 or 3 of their important ministries are actually with the union government, whether it is the law and order or whether it is communications or revenue. So, there are 2-3 important topics: land, police and order. So, all these are with the union government. So, they do not need a home minister. So, in that sense their bar has been set at a lower pace. So, this is what you should remember. Again, the 6-month rule also applies to the Union Council of Ministers. The 6-month rule, that means that any person who is not a member of either house of state legislature can again also become a minister, provided that he becomes a member of any house within 6 months. So, a non-member can also become a minister, provided he becomes a member of either house, either assembly or council within 6 months of such appointment as the minister. Then the advice that is tendered by the State Council of Ministers to the governor is binding on the governor. So, the advice that is tendered by the State Council of Ministers to the governor is binding on the governor. The same way it is binding, the Union Council of Ministers advice is binding on the president, the same way the State Council of Ministers advice is also binding on the governor. Some other parallel provisions are there. Tell me in the comment section, the Union Council of Ministers is collectively responsible to. Yes, the Union Council of Ministers is collectively responsible to whom? To whom is the Union Council of Ministers collectively responsible? Yes, someone is saying Prime Minister, others should also reply. I am asking, to whom is the Union Council of Ministers collectively responsible? Collectively responsible. Union Council of Ministers. Yes, Prime Minister. All of you are saying Prime Minister. Legislative Assembly. No. Okay, I will write the option Legislative Assembly. I am asking about Union Council of Ministers, not State Council of Ministers. Someone has said Lok Sabha. So, yes, the answer is actually Lok Sabha. The Union Council of Ministers is collectively responsible to the Lok Sabha. Now, the reason I told you that in Lok Sabha, no confidence motion can be passed. No confidence motion can be passed. That means if the Lok Sabha passes a no confidence motion, all of the ministers will have to resign, because the ministers or Union Council of Ministers are collectively responsible to the Lok Sabha. So, the Prime Minister, no. Legislative Assembly, no question of that. However, if we say State Council of Ministers here, if we make it State Council of Ministers, then the answer would be Legislative Assembly. So, the State Council of Ministers is collectively responsible to the Legislative Assembly of that particular state, because again the Legislative Assembly can pass no confidence motion against the ministers. Right? Now, if I ask you that the State Council of Ministers is collectively responsible, so if the word is collective, then the answer is the Assembly or Lok Sabha. But if I ask you individually responsible, then what is the answer? To whom are the ministers individually responsible at the union as well as at the state level? Let us talk about the state level. So, at the state level, the ministers are individually responsible to whom? To whom are the state ministers individually responsible? Someone is saying governor. Yes, someone else? Try to answer this question. To whom are the state ministers individually responsible? So, yes, governor is the right answer. Ministers are individually responsible to the governor. Similarly, at the union level, the ministers are individually responsible to the President of India. Right? Then let us see the classification of ministers or various types of ministers that can be there. Again, the classification is the same as in the case of the Union Council of Ministers. At the top comes the cabinet ministers, second comes the ministers of state, who are of a junior rank and who are there to assist the cabinet ministers, and on the last comes the deputy ministers. In the last comes the deputy ministers. So, this again the composition is the same as in case of the Union Council of Ministers. Right? If you have any question, you can ask me in the comment section. So, we have discussed the state executive, which includes the governor, the chief minister and the State Council of Ministers. Let us now discuss the state legislature. The state legislature. Now, this has some very important points as far as your preliminary exam is concerned. So, we will be discussing some very important figures which you should not miss while discussing the state legislatures. So, state can maximum have 2 houses. The upper house is the Legislative Council and the lower house is the Legislative Assembly. Now it is mandatory. Now it is mandatory for every state to have a legislative assembly, but it is not mandatory for a state to have a legislative council. It is mandatory to have a legislative assembly. That is why all the 28 states have legislative assembly, but legislative council is not mandatory, and it is only reserved for the bigger states. So, first of all, let us see the strength of the legislative assembly. So, what can be the minimum as well as the maximum strength of legislative assembly? Yes, as per the Constitution of India, the minimum strength of an assembly can be 60 and it can go up to 500. The minimum possible strength of an assembly is 60 and it can go up to 500. However, there are certain states where this limit has been breached, not the upper limit. As far as the upper limit is concerned, all states abide by it, and the state having maximum number of MPs is maximum number of MLAs is UP, which has around 403 MLAs. So, the upper limit is sacrosanct, but as far as the lower limit is concerned, there are certain states like Goa which do not have even that much of population that they can have so many members in the legislative assembly. So, there are certain states, for example, Arunachal Pradesh, Sikkim and Goa. So, Arunachal, Sikkim and Goa are the examples of some of the states where the MLAs are even less than 60. So, in some cases the MLAs are 40, or in some cases the MLAs are even 30. So, this particular provision has been done under Article 371, just like I told you. So, in some provisions there is special power to the governor, whereas in other provisions under Article 371 there are provisions where this below or lower cap can be removed. Similarly, as I told you, the governor can nominate one member in every legislative assembly from the Anglo-Indian community. The governor can nominate one member in every legislative assembly from the Anglo-Indian community. Also, there is reservation for scheduled castes and scheduled tribes in the legislative assembly. So, these again are the same provisions which were there in the Parliament of India or in the Lok Sabha that we discussed. The anti-defection law you are asking me, and the Uniform Civil Code. So, we have already discussed it in the class, but just to tell you in brief, anti-defection law is mentioned under the 10th schedule of the Constitution, which was added by 52nd Amendment, and under this particular law, any elected representative, either an MP or an MLA, if defects with his own party, then he can be disqualified. Now, defection can be of two types. One, if a person who has won a particular election on a one party ticket, but after winning the election he tries to change his party, that will come under defection. And second form of defection is if an elected representative defies his own party whip. A party is asking him to do or not to do something, and the MP or MLA goes against the party line, then that person can be disqualified. So, this is the anti-defection law. But there is one provision, so we will discuss anti-defection law in detail as well, that if out of the total strength of the legislative assembly size, out of the total strength of the legislature party in the assembly, if 2/3 of members try to separate from that particular party, only then that defection will not be counted as a defection. The next question is, Uniform Civil Code in the DPSP ensures national integration or economic equality. So, the answer is national integration, of course, because Uniform Civil Code means that all the religions, irrespective of which religion you belong to, the civil code of all the religions shall be the same. Say the provisions for marriage, adoption, maintenance and guardianship. So, all these, the legal provisions for all these will be the same. That means we are trying to have a uniform civil code for the entire country for all the religions, then that would ensure national integration. So, national integration would be the correct answer for that. Next important thing is, now let us see the Legislative Council. This was Legislative Assembly. Now, let us see the Legislative Council. So, in Legislative Council, the strength is very important. Now, this is a very important topic. So, the strength as far as legislative council is concerned, the minimum strength is fixed at 40. So, there cannot be less than 40 members in the upper house. The minimum strength of a legislative council can be 40 and the maximum strength can be 1/3 of the strength of the legislative assembly of that particular state. This is a very important provision, you can star mark this. So, this can be asked just like the strength of legislative assembly, lower limit is 60 and the upper limit is 500. For the upper house of a state, that is the legislative council, the minimum strength is fixed at 40 and the upper limit is set at the 1/3 of the strength of the legislative assembly of that particular state. Now, let us do an example. In Punjab, there are 117 members of the legislative assembly, right. So, if we do 1/3 of this particular sum, what comes out is 39. That means, if we make an upper house in Punjab, because Punjab does not have a legislative council, but if in a case Punjab demands that we should have a legislative council, the strength of that council cannot be more than 1/3 of the total legislative assembly members of that particular state. In this case, it will come out to be 39. However, the minimum limit is set at 40. That means Punjab cannot have a legislative council. Now, what it means is that the minimum strength is at 40 and the maximum is at 1/3. So, a state needs at least 120 MLAs in order to have a upper house. This provision has been done so that the smaller states do not press for a upper house. So, a state needs to have at least 120 members in the legislative assembly if it needs to have a upper house, and that is the reason why all the big states have a legislative assembly and small states do not. And this upper limit has been put in place so that the upper house does not dominate the lower house, because the lower house is the directly elected house and the upper house is not the directly elected house. Now, we will see the composition of this also. So, first of all, let us see how this house is composed, which is very important. So, out of the total strength of the legislative assembly, legislative council, I am sorry. So, we are discussing the composition of the legislative council now. So, let us not be confused. So, we are discussing the composition of the legislative council. First of all, 1/12 of the members, 1/12 of the members are to be elected by 1/12 of the members of the legislative council are to be elected by the members of local bodies. Now, local bodies include panchayats, municipalities and all other local bodies of that particular district, of that particular state. Then again 1/12 of the members are to be elected by the graduates of that particular state residing within the state, and they need to have 3 years standing. The graduates need to have 3 years standing. That means those who have done their graduation and it has been 3 years which have lapsed since they became graduates. So, this provision has been done to ensure that the literate people come forward to vote and they elect the members of legislative council. So, by this particular method, the people of the legislative council are chosen. Similarly, then again 1/12 of the members are to be elected by the teachers, in that particular state who have 3 years standing and who should not be less than secondary school teachers. So, the teachers who have 3 years standing and they should not be below the secondary school. So, elementary school teachers, that means, are not eligible to vote for the legislative council members. Then comes another composition, that is 1/3 of the total members are to be elected by the members of the legislative assembly of that particular state. So, this is very simple. The MLAs elect the MLCs, but only 1/3 of MLCs can be elected by the MLAs. So, that leaves us with around 1/6 of the total members. So, 1/6. So, that leaves us with 1/6 of the total members. These are nominated by the governor of the state, and the governor nominates these members from the fields of art, science, literature, social service and cooperative movement. So, this is the composition of the legislative council that you should never forget. So, the total of 5/6 of the members are elected and 1/6 of the members are nominated by the governor. So, this is the composition of the legislative council. So, this house is not composed of directly elected members, all these members are indirectly elected, and these are nominated. This is how the upper house of the state legislature is composed of. If you have any question, you can ask me. If you have understood this properly, kindly comment so that I can know that you have understood this. Okay. Then let us talk about the tenure of legislative council. The tenure of the legislative council again is parallel to that of Rajya Sabha. So, the tenure of legislative council members is 6 years, and 1/3 of the members retire after every 2 years. Now, this again has been done to ensure continuity in the house, the same way it was done in the Rajya Sabha. If we talk about the eligibility to become members of legislative assembly and legislative council, the eligibility, there is one major difference and most other points remain the same, and that difference is that to become a legislative assembly member, one needs to be at least 25 years of age, whereas to become a legislative council member, one needs to be at least 30 years of age. The same difference that is there in the membership of Lok Sabha and Rajya Sabha. So, for Lok Sabha, a person should be a minimum of 25 years of age, and for Rajya Sabha, a person should be of 30 years of age. That rule applies here as well. Okay. Right. So, now let us see in very brief the provisions for the presiding officers of these houses. So, the provisions are again exactly parallel to that of the speaker and deputy speaker of Lok Sabha and the chairman and deputy chairman of Rajya Sabha as far as the presiding officers of these two houses are concerned. But there is one major difference that we need to understand. So, in parliament we discussed for Rajya Sabha we did chairman and deputy chairman, and for Lok Sabha we did the offices of speaker and deputy speaker. Similarly, the same offices are there as far as legislative council and legislative assembly are concerned. So, the offices are exactly the same, all the provisions are the same. They conduct the house whenever they are sitting over the house, they can move resolutions, they can allow any member to speak or not to speak, right. They submit their resignations to each other, the chairman to deputy chairman to chairman, and they are administered their oaths by the governor of the state and vice versa. So, all these things are the same. However, there is one major difference, and that difference is regarding this particular designation. So, we know that in Rajya Sabha the chairman is the vice president of India. So, vice president is the ex officio chairman of Rajya Sabha. However, in case of a legislative council, there is no such post at the state level. There is no post of vice governor or deputy governor in a state who can actually become the chairman of legislative council. That means chairman is also elected by the house, just like speaker, and deputy chairman. That means the post of chairman of a legislative council is not ex officio, and the vice president is not a member of Rajya Sabha, whereas the chairman of legislative council is a member of legislative council. Now, this is the major difference. So, the chairman is a member of the legislative council. So, we had discussed that in case of Rajya Sabha and Lok Sabha, for out of these 4 office bearers, it is only the chairman of Rajya Sabha who is not a member of either house of parliament. All the 3 have to be the members of their respective houses. However, in case of state, all the 4 have to be members of the state legislature. So, the chairman and deputy chairman have to be the members of legislative council, and the speaker and deputy speaker also have to be the members of legislative assembly. This is one major difference that you need to understand. Right. So, simply this was state legislature. All other provisions are exactly parallel to that of the presiding officers of the parliament. Now, let us do the judiciary at the union as well as at the state level. So, first of all, let us do the union judiciary, which is the Supreme Court of India. So, I had left judiciary last time we discussed because I wanted to discuss both the Supreme Court and the High Courts at the same time, since most of the provisions are exactly parallel. So, the Supreme Court of India is the highest judicial body in India, and the maximum composition of Supreme Court, the maximum permissible composition of Supreme Court is 34, including the Chief Justice of India. Can you tell me in the comment section who is the present Chief Justice of India? Yes, who is the present Chief Justice of India? Please tell me in the comment section. So, yes, Mr. Sharad Arvind Bobde or S.A. Bobde is the Chief Justice of India at present, and the total strength of the Supreme Court is 34, which has been done just a few months back. Before that, the total strength of the Supreme Court was 31, including the CGI, but now it has been increased to 34, including the Chief Justice of India. So, the provision for Supreme Court of India, before independence, the Supreme Court of India was known as the Federal Court of India. Before independence, it was known as the Federal Court of India by virtue of the Government of India Act of 1935. However, after the Constitution came into being, the provision for the Supreme Court was made under Part 5 of the Constitution. Now, Part 5 deals with the Union. So, under this, from Articles 124 to Article 147, the provision for the Constitution of India The provision for the Supreme Court of India was made in the Constitution of India. So, if we talk about the judges, now the judges of the Supreme Court of India are appointed by the President of India under his hand and seal. So, it is the President of India who actually appoints all the judges of the Supreme Court of India. Right? There is a very important topic we are going to discuss right now, and that topic is that how the Supreme Court and High Court's judges are appointed. That system is known as the collegium system. That system is known as the collegium system. So, collegium, this word is made from the word college, and college means a group. Now, in this case, the Chief Justice of India plus the 4 senior most judges, of Supreme Court constitute the collegium for this purpose. So, the Chief Justice of India plus 4 senior most judges of Supreme Court, they decide 3 things. Number 1, who will become a High Court judge. Number 2, the transfers of High Court judges. So, who will become new High Court judge? Number 2, the transfer of High Court judges from one High Court to another, and number 3, the elevation or promotion of High Court judges to the Supreme Court of India. All these 3 things are decided by the collegium, which is composed of these top 5 judges of India, and these recommendations are sent to the President, who then implements these recommendations. That means the executive and legislature have virtually no role to play in the appointment of higher judiciary in India. So, all the High Court and Supreme Court judges, their appointment as well as their transfers are governed by the collegium, which is composed of judiciary itself, and where executive and legislature have virtually no role to play. Right? So, this collegium system is a judicial innovation. It was not originally provided in the Constitution. It was provided in various judgments of the Supreme Court, known as the first judge's case, the second judge's case, and the third judge's case. So, in these cases, this system came out that the judges should appoint judges, so that the executive and the legislature cannot interfere in the functioning of the judiciary. So, this was the logic that was given by the Honorable Supreme Court of India in various judgments. The oath to the Supreme Court judges is administered by the President of India. The oath to the Supreme Court judges is administered by the President of India. The tenure of the judges is up to 65 years of age. So, the Supreme Court judges can serve up to 65 years of age. Now, very importantly, we will talk about the removal of Supreme Court judges. What you need to understand is that the Constitution of India does not contain the procedure for removal of Supreme Court judge, and it rather empowers the Parliament to decide such a procedure. And in this particular regard, the Judges Enquiry Act, prescribes the procedure through which the Supreme Court judges can be removed. Right? The Judges Enquiry Act was passed in the year 1968, and this act prescribes the procedure. In the Constitution, it is simply written that a judge can be removed by the order of the President on 2 grounds. Those 2 grounds are proved misbehavior and incapacity. Proved misbehavior and incapacity are the two grounds on which the judges of Supreme Court can be removed, but the entire detailed procedure is carried in this particular act, Judges Inquiry Act. So, let us see the procedure. The first step is that if a judge has to be removed, 100 members in case of Lok Sabha or 50 members in case of Rajya Sabha have to sign a resolution to be introduced in that particular house. So, in case of Lok Sabha, if 100 MPs give in writing to the presiding officer of that house, and in case of Rajya Sabha, if 50 members give in writing to the presiding officer of that house, the procedure can be initiated. The second step is that the presiding officer, he can be speaker in case of Lok Sabha and chairman in case of Rajya Sabha, may or may not admit the particular motion. So, the speaker or chairman may or may not admit that particular motion. Now, it looks like a very simple point, but this can be a decisive factor. For example, 2 years back, against Chief Justice of India, Justice Deepak Misra, an impeachment proceeding was initiated, where more than 50 members of Rajya Sabha gave in writing to the chairman of Rajya Sabha to initiate the removal proceedings against Chief Justice of India, then Chief Justice of India, Justice Deepak Misra. However, it was not admitted by the chairman of Rajya Sabha at that time, who was Mr. M. Venkaiah Naidu. So, he refused to admit this particular motion, and that is why the motion lapsed on this particular stage itself. So, this is very important, that even if the MPs sign that particular resolution and give it to the presiding officer, he may or may not admit that particular motion. Now, the third step is, once the motion is admitted, a 3-member committee has to be constituted. A 3-member committee has to be constituted by the presiding officer of that particular house to investigate into the charges that have been leveled against that particular judge. So, this is the third step. And this particular committee's composition, this 3-member committee should consist of, number 1, a judge of Supreme Court, number 2, a Chief Justice of a High Court, and number 3, a distinguished jurist. So, this committee shall be composed of these 3 people, any judge of High Court, judge of Supreme Court, and number 2, a Chief Justice of a High Court, and number 3, a distinguished jurist. Right. The next step is, if the committee finds the judge to be guilty, only then the motion can be taken up further. It is not that the committee will investigate and submit its report. It matters what is the finding of that particular committee, since this committee is composed of the judges of Supreme Court and High Court. So, whatever the findings of this particular committee are binding on the House. So, only if this committee finds that the judge is guilty can the proceedings be taken up. So, if the committee finds that the judge is guilty, the House can take up the consideration of the motion. Now, after this, there is voting in both the houses. First of all, voting is in first house, then it goes to the second house. Now, this voting is to be done by special majority, and special majority means 2/3 of members present and voting and the majority of total strength of the house. So, after that, voting is done in the first house, and then it goes to the second house, where also the voting happens. And once the voting happens, after that it goes to the President of India, that is the last step. So, then it goes to the President of India, and when the President signs it, the judge is deemed to be removed. Now, if we compare this same procedure with the impeachment of the President of India, we can see various differences. The first difference is that in case of the President of India, what we required was that the motion has to be moved by 1/4 of the total strength of the House. In this case, it is 100 members in case of Lok Sabha and 50 members in case of Rajya Sabha. Secondly, the 3-member committee which is constituted in the first house itself, in case of the president, the second house acts as the investigating house, not the first house, but in this case the first house acts as the investigating house. Secondly, only if the committee finds that judge to be guilty can the motion be taken up, but this is not so in case of president. In the case of president, the committee just has to submit its recommendations, and it is up to the house to impeach or not to impeach the president after that. So, these are certain variations, and also even after the motion is passed by both the houses, it goes to the president for signature, but in case of impeachment of president, once the second house passes the resolution, the president is deemed to be impeached. So, all these are the contrasts and comparisons as far as the impeachment of a judge and the impeachment of a president are concerned. Right. So, this is very important, the procedure for impeachment of a judge of the Supreme Court. Then the independence of Supreme Court judges. The independence in impartiality of the Supreme Court judges has to be maintained, and for that purpose there are various provisions in the Constitution. The first provision is the way they are appointed. So, their appointment. Now, we know that they are appointed by the president only in theory. So, they are not actually appointed by the president, they are actually appointed by themselves. So, the judges appoint judges by the way of collegium system. So, their way of appointment is such that the executive and the legislature do not play any role in their appointment. So, that is how they are supposed to be impartial. Secondly, their tenure is secure. So, they serve up to 65 years of age, which ensures that they cannot be removed earlier. If they have to be removed, the procedure is very cumbersome, which we just discussed. So, their security of tenure is provided to them. Third, their service conditions. Now, service condition means that their expenditure is charged on the Consolidated Fund of India. Expenditure is charged on the Consolidated Fund of India, which means that it is not voted by Parliament, not voted by the Parliament every year. It is fixed, so that they have economic security and they cannot be pressurized on that particular behalf. Then the conduct of judges. The conduct of judges not to be discussed. The conduct of the judges of Supreme Court cannot be discussed in the house of any parliament or anywhere unless a motion for their removal is under the consideration of the house. So, either in parliament or in a state legislature, the conduct of the judges cannot be discussed. They are barred from this. Then there is a ban on practice of law after retirement. So, they cannot practice law after they retire from the or as judges of the Supreme Court of India, because in that they can be influenced. That is why they cannot take up any cases, they cannot have any clients, and they cannot associate with any law firm after their retirement. Also, its jurisdiction cannot be curtailed. So, the jurisdiction of Supreme Court can only be increased, but it cannot be decreased. So, the jurisdiction cannot be curtailed. The staff of the Supreme Court is totally under the discretion of the Supreme Court judges. So, they can appoint any number of staff and they have to be provided for that by the Parliament of India. Similarly, this is the only court, not the only court, this is a court which can punish for its contempt. So, if any decision of the Supreme Court is not implemented, or if the Supreme Court is unfairly criticized over any public fora, they can punish anyone for the contempt of court. Right? Then there are various types of jurisdictions of Supreme Court, like the original jurisdiction, the writ jurisdiction, the writs that we discussed, like the habeas corpus, quo warranto, prohibition, certiorari and mandamus. So, all those writ petitions can be entertained by the Supreme Court. In original jurisdiction, all the interstate disputes are actually handled by the Supreme Court of India. Then there is the power of review of the court, of any decision of any court. So, this court, particularly the Supreme Court of India, acts as the overriding court over every other court and tribunal of the country. So, any case anywhere in any court of India can be appealed in the Supreme Court of India, and Supreme Court is the highest court as far as the Union of India is concerned. Some important powers of the Supreme Court, let us discuss. The first power is, the type of jurisdiction is original jurisdiction. Now, in original jurisdiction, what it means is that those cases which can directly come only to the Supreme Court of India and they cannot go to any other court. Those decisions are the federal disputes. Now, federal disputes means any conflict between a state and another state, or more than one states. Similarly, any dispute between a center and a state, or more than one states, or any dispute where the center and state are on one side versus other states or state are on the other side. So, all these disputes are the original jurisdiction of the Supreme Court of India. For example, if there is a dispute between the state of Punjab and Haryana, they cannot go to any high court, they have to directly go to the Supreme Court of India, because the original jurisdiction in that regard is with the Supreme Court of India. Similarly, if there is a dispute between any union, between any state government and the union government, then also it is the original jurisdiction of the Supreme Court of India. Then it acts as an appellate court. Appellate court means all the appeals, either from the civil matters or criminal matters, culminate in the Supreme Court of India. Third and very important is the writ jurisdiction of the Supreme Court. Now, in writs we mean all the writs that are mentioned under Article 32 of the Constitution. They can be taken up by the Supreme Court of India under the writ jurisdiction of the Supreme Court. Also, in context of the appellate jurisdiction, there is one very important thing that we need to discuss, which is the special leave petition. Special leave petition. Special leave petition is a special type of petition that can be filed in the Supreme Court. Now, this means that if any decision of any court anywhere in India is to be challenged directly in the Supreme Court of India, then this particular petition has to be filed in the Supreme Court of India. This discretion is there with the Supreme Court of India. It is a discretionary power, so it cannot be claimed as a matter of right, but say any lower court or any tribunal or any special court or any fast track court delivers a judgment and there is such a violation of law in that particular judgment that you want to appeal against it directly in the Supreme Court of India. For that, all you have to do is file a special leave petition or SLP for that in the Supreme Court of India. Now, this SLP is available against all types of courts except the military courts and the court martial. So, the only exception is military courts or court martial. Against this, SLP cannot be issued because these courts are totally separate and they do not come under the ambit of the Supreme Court of India. Then another important one is the advisory jurisdiction of the Supreme Court. Now, advisory jurisdiction means that the Supreme Court can advise the President of India whenever the President asks him to do so. For example, such a topic or such a issue may come up before the President that requires a very deep knowledge of law and legal jurisprudence and facts, and for that particular topic the President can seek the advice of the Supreme Court of India under Article 143. So, under Article 143 of the Constitution, the President of India can seek the advice of the Supreme Court of India on a matter of law or fact, and the Supreme Court provides such advice to the President. However, very importantly, such an advice tendered by the Supreme Court of India is not binding on the President of India. Such an advice is not binding on the President. So, the President may or may not heed such advice, but he can seek such a advice. Similarly, the Supreme Court acts as a court of record, which means that all the judgments and orders of the Supreme Court of India are published for further review. They can be used as precedents in other courts of law. Then there is power of judicial review. The power of judicial review, which means all the laws passed by the Parliament of India or by the state legislature can be reviewed by the Supreme Court of India to check whether they violate any of the provisions of the Constitution of India or not. Right? So, the power of judicial review is also there with the Supreme Court of India. So, this was the topic of Supreme Court of India in brief: the total strength of judges, the way they are appointed, the way they can be removed, and the collegium system and various types of powers of the Supreme Court of India. Now, similar to this are the powers of a High Court. So, at the state level, there is a High Court of India. There is a High Court for every state. Now, can you tell me how many High Courts are there in India? Can you tell me in the comment section how many High Courts are there in India? So, there are a total of 25 High Courts in India. 25 High Courts in India. That means, yes, so Barinder has, you are saying it correctly, there are 25 High Courts in India, and the latest High Court was the Sikkim High Court. Before that, 3 High Courts were also established some 5-6 years back. 3 new High Courts were established for 3 northeastern states. So, there are a total of 25 High Courts in India at present. Those states were Tripura, Manipur and Meghalaya. Tripura, Manipur and Meghalaya. So, in these 3 states, the high courts were made, and now there are a total of 25 high courts in India. So, who appoints the judges of a high court? They are appointed by the President of India. Now, as I told you that as far as the legislature and executive are concerned, they are totally different at the union and state level. But when it comes to judiciary, we have the concept of integrated judiciary. We have the concept of integrated judiciary. Now, integrated judiciary means that the judges of high court become the judges of Supreme Court, and it is not a separate mechanism. So, the judges of Supreme Court and High Court are organically linked with each other. That is why there is integrated judiciary. So, if the judges of Supreme Court are appointed by the President, the judges of a High Court are also appointed by the President of India. Right? But as far as the oath of High Court judges is concerned, it is administered by the governor of that particular state. That means the President has delegated his power to the governors of states as far as the oath of those judges is concerned. Then let us see the qualifications of those judges who all are qualified to become judges of High Court of India. Now, the qualifications are in terms of their merit and their experience. So, they should be citizens of India. Now, this is a must that they should be citizens of India. The second is that they should have held a judicial office for at least 10 years. So, they should have held a judicial office for at least 10 years, or they should have been an advocate for at least 10 years. So, either of these conditions have to be met if they want to become the judges of the High Court. And this particular provision in case of the Supreme Court judges is also the same. So, I did not discuss it at that time because I wanted to draw a parallel here. So, in case of the qualification of High Court judges, they should be citizens of India, and also either of these two situations has to be met. Either they should have worked as an advocate for 10 years, or they should have held a judicial office for 10 years. Now, as far as Supreme Court judges are concerned, the first condition is the same, that they have to be the citizens of India. Now, in the second condition, as far as the second condition is concerned, they should have been a judge of High Court. Now, this is important, a judge of High Court for 5 years. They should have been a judge of a High Court. Now, here they are saying the judicial office, that means a lower judicial office. It can be a district judge, it can be a civil judge or a sessions judge for 10 years. Whereas, here a person needs to be a judge of a High Court, which is a very larger, very bigger requirement. So, he should be a judge of High Court for at least 5 years if he wants to be considered himself as a or herself as a judge of the Supreme Court. Similarly, he should have been an advocate of a High Court or Supreme Court, of a High Court or Supreme Court for at least 10 years. Now, here also the advocacy is should be only of the High Court or the Supreme Court. Now, this is another significant change. The third requirement is that the person can be a distinguished jurist. That means, even if a person has never been a judge of a High Court or has never practiced in the court, even that person can be appointed as a judge of the Supreme Court of India. Now, this is a very significant departure from this particular provision. So, if we see, as we compare and contrast the difference between a High Court judge's qualification and a Supreme Court judge's qualification, the major differences are: number one, that here the judicial office should have been held for 10 years, and here the judgeship should only be of a High Court. Secondly, there is no provision for a distinguished jurist to be appointed as a judge of High Court, whereas a distinguished jurist can be appointed as a judge of Supreme Court of India. Now, this provision has been done here because even if a person is not practicing law as an advocate, or even if a person has never been a judge, but he has been really good at law, he has been a distinguished jurist, which can be the professors of law, which can be the members of law commission, which can be the people who are really good at law, but they have never practiced it or have never been judges. Even they should be given an opportunity to be represented at the highest court of the land, so that their experience can be used in the Supreme Court of India, and only Supreme Court of India because it is concerned with the interpretation of the Constitution. High courts generally do not interpret the Constitution, but Supreme Court does, and that is why this provision has been done. Recently, under this particular provision, Justice Indu Malhotra of the Supreme Court of India was appointed. So, Justice Indu Malhotra was appointed. She is a distinguished jurist. So, yes, as rightly said in the comments also. So, this provision is there. This is the major difference as far as the qualification of High Court and Supreme Court judges are concerned. Again, if we talk about the tenure of the High Court judges, there is no fixed tenure. There is no fixed tenure for a High Court judge. However, there is an upper limit of 62 years of age. There is an upper limit of 62 years of age, whereas in the case of Supreme Court of India, it is 65 years of age. So, here this is the difference, that the tenure of judges is 62 years of age. Right. As far as the removal of these judges is concerned, the procedure is the same as we discussed in case of the Supreme Court of India. So, the procedure is mentioned under the Judges Enquiry Act, under which the High Court judges can be removed. Now, the procedure is the same. It has to be done in Parliament only. That means the state legislature has no role to play. Now, very importantly, even if it is a state High Court, the state legislature does not have any say in the removal of the High Court judges. So, this is a prerogative of the Union Parliament only. It can be done only by Lok Sabha and Rajya Sabha and not by the state legislature. This is very important. The entire procedure remains the same, either 100 members of Lok Sabha or 50 members of Rajya Sabha, and then it is admitted by the presiding officer of the House, etc. Right. So, then the salaries. Now, another important point is that the salaries of the of the High Court judges are given by the central government, but the pensions of High Court judges are given by the state government. But the pensions are given by the state government. Justice Indu Malhotra was an advocate of Supreme Court, not a distinguished jurist. I was also thinking the same, but someone commented, so I thought. Justice Indu Malhotra has been a judge, has been an advocate in the Supreme Court for quite some time now. I don't know whether she qualifies under the 10-year criteria of practice or not, but she has never been a judge of Supreme Court or High Court earlier. So, she has been elevated directly to the bench. Can you give me an example of a distinguished jurist? Any person who has been a distinguished jurist and has been appointed as a judge of the Supreme Court. I cannot recall any name right now of a distinguished jurist who has been appointed as a judge of Supreme Court, because it is anyway very rare. In fact, the appointment of Justice Indu Malhotra was also very rare, because it is very rare that an advocate is directly appointed a judge of Supreme Court of India. Generally, an advocate is appointed as a judge of a High Court, then he becomes a Chief Justice of a High Court, and only then he gets to be elevated to the Supreme Court of India. Never, I won't say never, it is very rare that an advocate is directly made a judge of the Supreme Court of India. So, in that case, Justice Indu Malhotra's case was unique, you are right. So, I confused it between those two. I do not know if ever a distinguished jurist has been appointed as a Supreme Court judge or not, and that needs to be checked. Similarly, if we talk about the provisions for ensuring the independence of a High Court, if we talk about the provisions for ensuring the independence of a High Court, they are the same as that of the Supreme Court of India. So, there is security of tenure. There is security of tenure. There is security of tenure. Then their salaries and allowances are charged on the Consolidated Fund of India. Now, very importantly, as I already told you, their salaries are given by the central government, but their pensions are given by the state governments. So, whichever state, in whichever state High Court the judge has retired, that particular state has to provide pension to that particular judge. This is a convention. So, their salaries are charged on the Consolidated Fund of India, so they cannot be tinkered with. Similarly, their conditions of service cannot be varied. Their conditions of service cannot be varied to their disadvantage. That means they cannot be pressurized either by the executive or the legislature. Perhaps you are right, their salaries are given by the state and their pensions are given by the center. Yes, you are right, their salaries are given by the state government and their pensions are given by the center. So, you are right, since it is integrated judiciary, the burden of their pension falls on the center government. If you have any doubt, you can ask me. I have just clarified that the salaries of High Court judges are paid by the state government and their pensions are paid by the center government. If you have any doubt, you can ask me. Right? Similarly, there are some other provisions that there is ban on their practice after retirement. There is ban on their practice after retirement. Similarly, their conduct cannot be discussed in the state assembly or in parliament. Their conduct cannot be discussed in the state assembly or in the parliament except when a motion for their removal is under the consideration of the House. Similarly, their jurisdiction cannot be curtailed, their jurisdiction cannot be reduced, and they have power with regard to appointment and selection of their staff. So, that administratively there can be no problem as far as High Courts are concerned. All other powers of the High Court of India are the same as that of the Supreme Court of India. So, now let us see some of the high courts which are the combined high courts of certain states or union territories, or what are their jurisdictions. First of all, the name of the High Court is the Punjab and Haryana High Court, We will discuss only those high courts which have multiple jurisdictions, which are not the high courts of one particular state. So, the Punjab and Haryana High Court administers the states of Punjab, Haryana and the UT of Chandigarh. This is the first such high court. Similarly, the High Court of Calcutta or the Calcutta High Court, it administers the state of West Bengal. It administers the state of West Bengal and also the Union Territory of the Andamans and Nicobar Islands. The Andaman and Nicobar Islands. Then there is Guwahati High Court. Then there is the Guwahati High Court. Now, this Guwahati High Court used to administer 8 states earlier, but now that 4 new high courts have been made, the burden of the Guwahati High Court has reduced significantly, and now the states that come under the Guwahati High Court are the state of Assam, the state of Nagaland, the state of Mizoram. These come under the High Court of Guwahati with their benches at the capital of Assam, that is Guwahati. No, it is not the capital of Assam. So, there is a bench in Guwahati, then there is a bench in the capital of Nagaland, that is Kohima, and then there is also a bench in the capital of Mizoram, that is Aizawl. So, there are benches in these particular places. Then there is Bombay High Court. Now, Bombay High Court administers Maharashtra and it also administers the Union Territory of Daman and Diu and Dadra and Nagar Haveli. Now, this is one single Union Territory. Earlier these were 2 different Union Territories, but now it is one single Union Territory because both of them have been merged. So, yes, Arunachal Pradesh also is a part of the Guwahati High Court. So, Maharashtra and the Union Territory of Daman and Diu and Dadra and Nagar Haveli also come under the Bombay High Court. Similarly, the Kerala High Court administers the state of Kerala as well as the Union Territory of Lakshadweep as well as the Union Territory of Lakshadweep. So, these are some important high courts and their jurisdictions. So, with this we have completed the state legislature, the state executive and the state judiciary. If you have any question, you can ask me, or we can and we will then proceed with a new topic. So, we have till today discussed the union legislature, union executive and union judiciary, and also the state executive, state legislature and state judiciary. So, we have covered these very topics. If you have any doubts, you can ask me. Yes, you can ask me questions. So, shall we begin with the next topic, which is a very small topic. The governor of a state, to whom is the governor of a state answerable to? Now, what do you mean by answerable? The governor of a state is answerable. This is not a proper question. The accountability of a governor is not to anyone. The governor is appointed by the center and maybe is accountable to the president of India only. That is your that is the best answer I can give. So, let us discuss as a part of executive only the last office that is left. With that, we will complete the executive, legislature and judiciary at all the two levels, center as well as state. Can you tell me which only executive authority we have left? I told you on day 1 that the union executive consists of the President of India, the Prime Minister of India, the Union Council of Ministers, and there was one more office that was there. Can you tell me which office is that? The Prime Minister, the President and the Union Council of Ministers. The office that is there is that of Attorney General of India. So, it is Attorney General at the union level, and the same office is known as the Advocate General at the state level. Let us first discuss the office of Attorney General of India. The office of Attorney General of India. Yes, so Attorney General of India is a part of Union Executive, number 1. Secondly, all the provisions relating to the office of Attorney General are decided by the President of India. All the provisions regarding the office of Attorney General are decided by the President of India. This provision of Attorney General is mentioned under Article 76 of the Constitution. This article is important because it is the only article under which the provision for Attorney General is there. No other article mentions Attorney General of India. So, since this is the only article, you can be asked under which article of the Constitution the Attorney General's provision is there. Some important provisions regarding the office of Attorney General are: number 1, there is no specific way to appoint or to remove a Attorney General of India. That means there is no procedure or ground for removal of the Attorney General of India. He is just like an advocate. So, we can also say that our Attorney General is the highest ranking advocate in India, or we can say that he is the highest law officer of India, the highest law officer of India. So, can you tell me in the comment section who is the Attorney General of India at present? Yes, Mr. K. Venugopal, Mr. K. Venugopal is the Attorney General of India at present. So, he is the highest law officer of India. So, there is no procedure or ground for removal of the Attorney General of India. The remuneration or salary is also not fixed by the Constitution. The remuneration or salary is not fixed by the Constitution. Another significant provision. So, all these things are decided by the President of India. In effect, it is decided by the Prime Minister along with his council. So, all these things are actually decided by the President of India Let us see some important provisions vis-a-vis the office of the Attorney General of India. What all powers he enjoys and what are his functions. So, his function is, since he is the highest law officer, he is the advocate of the government. That means in all the important cases of the government, he represents the government wherever he is sent by the government to represent it. So, that is the important point. The first thing is he enjoys the privileges of an MP. That means he enjoys the privileges of all that are enjoyed by a member of parliament. This is the first thing. Secondly, he can sit or speak in any house of parliament. Very important. He can sit and he can also speak in any house of parliament. Now, this is a very unique provision which has been granted to him. Since Attorney General is not a member of parliament, he only enjoys the privileges of a member of parliament, but he can also sit and speak in any house of parliament. This provision has been done so that if any legal point the government is unable to explain in the house, then Attorney General can be asked to come in the house and explain that particular point. However, this does not mean that the Attorney General can also vote in the house. The Attorney General cannot vote on any provision of any bill in the house of parliament. That means he can just sit there, he can just speak there, but he does not enjoy the right to vote in the house. This is very important. This is a question that has been asked to you in a previous year paper of a state civil services exam. The question was, which among the following rights is not enjoyed by the Attorney General of India? The first was he can sit in any house. The second was he can speak in any house. The third was he can vote in any house. So, the answer was the third one. So, he cannot vote in any house. Another important provisions regarding the Attorney General are, he can continue his private practice. He can continue his private practice. Even if he is engaged by the Government of India, that does not mean that he does not take up other cases as well. However, there is a clause, he cannot take up such cases which create a conflict of interest with the Government of India. That means he cannot take up any case in which the Government of India is a party to that case. That is a limitation on the Attorney General of India. Also, he is not a full-time counsel. Now, this is what it means. If he is a full-time counsel of the government, that means he cannot take up other cases. But since he can take up other cases, that means he is not a full-time counsel of the Government of India. He can also take up private cases. He can also take up private legal practice. Also, he is not a government servant. By definition, the Attorney General of India does not fall in the category of a government servant. So, he is not considered a government servant. The reason for this is that his employment is not a full-time employment, and also it is only for a particular period of time. So, it is for a few months or a few years. So, it is not considered a government service. Also, because it is not full-time, it is a part-time employment. Right? So, there are certain limitations on him. He cannot take up any case which is against the Government of India or where a government is a party. Also, he cannot take up any case in which the government has advised that it should not take it. Say for example, if there is an accused person in a criminal case and the Attorney General is trying to defend that person, the government can say that such a case should not be taken up by the Attorney General of India. So, such limitations can be imposed on the Attorney General of India for sure. Also, he cannot accept, he cannot become a director. He cannot become a director in any company or corporation without asking the permission of the government. He cannot become a director in any company or corporation without government permission. So, that is also important. The reason this is done is so that if he takes up any case of the government of India against that particular company or corporation, there will be conflict of interest. So, for that reason he has to take the permission of the government before becoming director in any company or corporation. So, all these are the provisions related to the office of the Attorney General of India. Additionally, there is also another office known as the Office of Solicitor General of India. The Office of Solicitor General of India. Now, this office is there to assist the Attorney General of India. This office is there to assist the Attorney General of India. If Attorney General is the highest law officer of the country, the Solicitor General is the second highest law officer in the country. Solicitor General is the second highest law officer in the country, but you should remember that the provision of a Solicitor General is not there in Article 76 of the Constitution. So, Article 76 mentions only about the Attorney General of India, not about the Solicitor General of India, and they are separately provided for by the Parliament of India. The similar office at the state level, can you tell me what the similar office at the state level is known as? I have already described you about that. So, the similar office at the state level is known as Advocate General. Advocate General. Try to find out the Advocate General of your own states. So, if you belong to Punjab, try to find out who is the Advocate General of Punjab or who is the Advocate General of Haryana, and as the case may be. So, the provision for Advocate General for a state is mentioned under Article 165 of the Constitution. Now, since he or she is a part of the state executive, so its provision is also made under Part 6 of the Constitution, which is the part that talks about the state. So, the state legislature, executive and judiciary, they are mentioned under Part 6, and the union executive, legislature and judiciary are mentioned under Part 5 of the Constitution. Now, almost all the parallel provisions are there in the office of Advocate General. Say Advocate General is the highest law officer of the particular state. Just like the Attorney General is the highest law officer of India, the Advocate General is the highest law officer of that particular state. Also, the Advocate General is appointed by the governor. He is also of the rank of an MLA. He also gets to sit in the state legislature, but he does not get to vote. So, all those provisions are totally parallel, right? So, all those provisions are totally parallel. All the conditions of service, their salary, allowances, everything is decided by the governor of that particular state, and all other provisions are totally parallel. Let us discuss two important provisions here, which will then sum up our topics of Attorney General and Advocate General. Let us discuss the difference between their qualifications. So, if there is Attorney General and then there is Advocate General, let us discuss their qualifications. Who is eligible to become Attorney General and who is eligible to become Advocate General? So, as far as Attorney General is concerned, the first provision is that he should have been a judge of a high court or an advocate of a high court. So, a judge of a high court for 5 years or an advocate for 10 years. This is the provision for Attorney General of India. Can a person be Advocate General for more than one state? I do not know of any such precedent, but definitely this provision cannot be there. A person cannot be an Advocate General for more than one state, because this is a very hectic job, this is a very full-time job. So, this it's not theoretically a full-time job, but a person is not expected to be a Advocate General of more than one state. So, the first qualification is that he should be either a judge of High Court for 5 years or an advocate of a High Court for 10 years or an eminent jurist. So, either of the three conditions has to be fulfilled for a person to be appointed as a Attorney General of India. However, if a person has to be appointed as a judge of a High Court, then he should have a judicial office for 10 years or an advocate for 10 years. In other words, a person equivalent to the judge of a Supreme Court of India, these same qualifications are prescribed for the judge of the Supreme Court, and these same qualifications are prescribed for the judge of a High Court. So, to become an Attorney General, a person should be qualified to become a judge of Supreme Court, you can say, and for becoming the Advocate General of a state, the person should be qualified to become the judge of a state High Court. That simply means that an eminent jurist cannot become a High Court judge. Similarly, an eminent jurist cannot become the Advocate General of a state, but an eminent jurist can become the Attorney General of India. So, this is a provision that you have to keep in mind. This is actually parallel provision. The Attorney General is in the Union Executive, so his qualification is also equivalent to the Union Judiciary or the Supreme Court of India. Similarly, the Advocate General is a part of the State Executive, so his qualification is also equivalent to that of a member of a State High Court or the State Judiciary. So, these provisions are actually parallel in both the cases. So, this is what you have to keep in mind. Also, there are certain common provisions in both Attorney General of India and Advocate General of India. They have the right to audience in any court throughout India. So, they can seek audience in any court, either Supreme Court or High Court or any subordinate court throughout India. They can also speak in any House of Parliament or of the state legislature, but they do not have the right to vote. And as far as Advocate General is concerned, they enjoy the privileges of a member of Legislative Assembly. Similarly, like the Attorney General enjoys the privileges of a member of Parliament. So, these are exactly parallel provisions that you need to keep in mind. So, with this we have completed the Union Legislature, Executive and Judiciary, and also the State Legislature, Executive and Judiciary. If you have any doubts, you can ask me in the comment section. So, thank you everyone. This has been the session on State Legislature, Executive and Judiciary. I hope you liked this session. Do let me know in the comment section. Thank you everyone.